Hello, I welcome all of you to this lecture on the jurisdiction of International Criminal Court, as well as the cases decided, some of the leading cases decided by the International Criminal Court. Students, I shared with you what are the subjects over which International Criminal Court has the jurisdiction. So, like our courts, sessions courts, they have jurisdiction over the crimes which are mentioned in the Indian Penal Code. Likewise, I told you that the International Criminal Court has the power over some of the crimes which are mentioned in the Rome Statute. What are those crimes? I told you that those crimes are 4 in number. First is the crime of genocide. Second is the crime of war crimes. The third is crimes against humanity. And the fourth is the crime of aggression. These are the crimes only. 4 kinds of crimes over which International Criminal Court has jurisdiction. Now you will wonder what is the meaning of genocide, because this is also generally misunderstood. Genocide is misunderstood because normally many people will say that genocide means massacres. Genocide means killing of large number of people. So this is not the right meaning of genocide. The right meaning of genocide is given in Article 6 of the Rome Statute. It says that genocide means any of the following acts. So these are the following acts, 5 acts which are committed with intent to destroy. My students, you might be knowing what is the importance of intention in criminal law, and then what kind of intention is needed to commit the crime of genocide. This intention must be to destroy, right? So destruction of a particular group, different types of groups. You have to identify a group out. There are how many groups which are mentioned in Article 6? Only 4 groups are mentioned. So what are those 4 groups? National groups. Second is ethnical groups. Third is racial groups. And the fourth is religious group. Out of these 4 types of groups, if any person selects one group or 2 groups and then starts destroying the members of those groups, then what will happen? That it may amount to crime of genocide. Now, destruction may be killing. Destruction may be by causing serious bodily or mental harm to members of the group. Destruction may be by deliberately inflicting on the group conditions of life which are calculated to bring about its physical destruction in whole or in part. The destruction may be also by imposing measures intended to prevent births within the group. And lastly, destruction may be by way of forcibly transferring children of the group to another group. So these are the 5 acts which, if committed with the intention to destroy that group, then it amounts to genocide. Students, I have told you some cases also. I discussed with you some cases on genocide when I discussed elaborately when I was discussing International Criminal Tribunal for the former Yugoslavia. And I told you about the cases of Kristic, Jeličić, and also Milosevic. Now, what I'll be dealing with, excuse me, I'll be dealing with the next subject matter jurisdiction, which is crimes against humanity, which is dealt with in Article 7 of the International Criminal Court Statute. And this International Criminal Court Statute says that crimes against humanity means any of these acts. Now, what are these acts? Now, these are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. 11 acts. How many acts can be committed which can be crimes against humanity? 11 acts. But how these acts are committed? These acts are committed as part of a widespread or systematic attack. And third, it must be directed against civilian population. So crimes against humanity is that kind of crime which can be committed only when it is directed against civilian population. Students, I have been telling you that international humanitarian law protects the civilians. And if you will not protect civilians, but the point is that international humanitarian law is applicable only when armed conflicts are going on. Now, in this Rome Statute, nowhere it is said that there is a possibility of conflict, armed conflict going on. Even when there is a peacetime, if these acts are committed against any civilian population, then what will happen that the crime against humanity can be committed. What are those acts? Those acts are murder. Those acts are exterminating. If you exterminate, if any act is going to exterminate, what is the meaning of extermination? Extermination is defined here. It is intentional infliction of conditions of life by which you deprive access to food and medicine, calculated to bring about the destruction of part of a population. So such kind of thing you do. Exterminate, you want to exterminate. Students, all of you might be now knowing that what is the importance of food and medicine. Even in the times of this corona disaster, we know that food and medicine, how these are important. And suppose if food and medicine are not given, access to food and medicine is not given, then that may be an act which may be crime against humanity. And then enslavement, you see, such kind of acts which are totally against the civilized conscience of the humanity. That is crime against humanity. Enslavement, you enslave. You know what is the meaning of enslavement? Enslavement means that you make some person a slave and you tell him to work for you, and then what you will do that you will not give him any remuneration. You see, this is also defined. Enslavement means exercise of any of the power attached to the right of ownership. You own the person, and then you say what it includes the exercise of such power in the course of trafficking in person, in particular women and children. So enslavement is a kind of, a kind of power. You enslave a person, and thereafter what you can do whatever, because you think that you own that person. So enslavement is horrible, and therefore it is a crime against humanity. Likewise, deporting a population. You deport a population. Without their will, you deport a population. Forcible transfer of population. You transfer the population forcibly. So in such cases, what will happen? It will be crime against humanity. And thereafter, likewise, such serious crime, you see, imprisonment in violation of fundamental rules of international law, torture, and then rape, sexual slavery, enforced prostitution, forced pregnancy. These are all very serious crimes against women. And therefore, if you remember, the International Criminal Tribunal for the former Yugoslavia, that had included rape as one of the act which can be crime against humanity, but it did not elaborate upon rape particularly. But then you might have seen that how in the Rwandan trial, Justice Navneetham Pillai, she had tried to give wider interpretation of this term of crime against humanity, and now this Rome Statute contains this kind of wider definition of crimes against women. So rape, sexual slavery, enforced prostitution, forced pregnancy, enforced sterilization, these are all very serious crimes, and likewise sexual violence of comparable gravity. So this is also widely, these words are widely open for interpretation. And then persecution. You might have heard about instances when people persecute against other group on political, racial, national, ethnic, cultural, religious, and gender. So there are how many groups? 7 groups. 1, 2, 3, 4, 5, 6, 7. 7 groups. So if there is a persecution against a group out of these 7 groups, then what will happen? And it must be against international law, universally impermissible under international law. Then what does it amount to? It amounts to crime against humanity. Enforced disappearance of person. If there are people who are made to disappear, who are not disappearing on their own, but who are made to disappear, forcibly made to disappear, this kind of act will be called enforced disappearance. And then crime of apartheid, and likely lastwise such kind of inhumane acts of, so these are inhumane, you see, crime against humanity are the examples of inhumane acts of a similar character, intentionally causing great suffering or serious injury to body or to mental or physical health. So these are all crimes against humanity. So International Criminal Court has the jurisdiction over crime against humanity. Likewise, International Criminal Court has the jurisdiction over war crimes. And you see this war crime. War crime is mentioned in Article 8. It says that war crimes can be committed when it is a part of a plan or policy, or which is a part of large scale commission of such crimes. So war crimes, as the name itself suggests, that war crimes can be committed only during war. Crimes against humanity can be committed even during peacetime. Genocide can also be committed in peacetime, but war crimes cannot be committed during peacetime. It says that the court shall have jurisdiction over war crimes when it is committed as part of a plan or policy or as part of large scale commission of such crimes. Now, what are the meaning of war crimes? Now, war crimes are divided into 4 categories. If you look at Article 8, you will find that 4 categories of war crimes. 2 categories are there for international armed conflicts. So the first category is Article 8, paragraph 2, subparagraph A, which says grave breaches of Geneva Convention. Torture. The torture is the grave breach of Geneva Conventions. And then inhumane treatment, biological experiments. And likewise, I have already discussed these things when I was discussing with you grave breaches of Geneva Convention, and therefore I am not again devoting much time on defining the grave breaches of Geneva Convention. You see these examples in all the Geneva Conventions, 4 Geneva Conventions, grave breaches are mentioned. So this is grave breaches. The other type of war crime, which can be not grave breaches, but which are serious violations of the laws and customs applicable in international armed conflict. So these are all examples of serious violations. You see, these are examples, and these are all rules which are mentioned in the Geneva Conventions. These are all, if you read these rules, these are all, we have discussed these rules in the Geneva Conventions. Look at some of these examples. You can see that if somebody intentionally directs attacks against buildings which are dedicated to religion, education, we have discussed it. Sometimes you might have seen that if you say that no quarter will be given, means nobody will be nobody will be saved of life. Everybody will be killed. So this is also a war crime. Likewise, employing poisonous weapons. Likewise, employing those bullets which expand easily in the human body. So these are some of the examples I have already told you. One of the things that I should mention, that this was not there in Geneva Convention, conscripting or enlisting children under the age of 15 years into the national armed forces or using them to participate actively in hostilities. Now, these are all the jurisprudence developed by the international criminal tribunals. Those were constituted after the Second World War. Now, after these two different types of war crimes which can be committed during international armed conflicts, Article 8, Paragraph 2, Subparagraph C and D, C and D and E, these are relating to non-international armed conflict. And then you see that C says that in case of non-international armed conflict, there must be no violation of Article 3, which is common to the 4 Geneva Convention. So serious violations of Article 3 common to the 4 Geneva Conventions, those are again amounting to war crime. And what are common Article 3? Violence to life and person, committing outrage upon personal dignity, taking of hostages, the passing of sentences, and the carrying out of execution without previous judgment pronounced by a court. So these are all war crimes. And then you will find that in subparagraph E of paragraph 2 of Article 8, it says other serious violations of the laws and customs applicable in armed conflicts not of an international character. And in such category also, so many examples are given. You see 15 examples are given. What kind of, employing poisoned weapons, employing gaseous weapons, employing bullets which expand easily, and then declaring that no quarter will be given. All these are there. So you find that these are the 4 different types of examples of war crimes which are mentioned in the Rome Statute. So students, what I was telling you, that these are the 3 types of crimes which are important. But one more type of crime which has been included in the Rome Statute is the crime of aggression, which is given in Article 5 as well as in Article 8 bis. So first of all, I will tell you about Article 5. You see, Article 5 says that the jurisdiction of the court is extending on the crime of aggression also. And then in Article 8 bis, bis means that which is added later. So Article 8, this article was not in the 1998 Rome Statute. This article was added when in the Kampala conference, which was organized in 2010. After that, it was decided by the Assembly of States Parties that the crime of aggression is also to be defined, and then it must be coming under the jurisdiction of International Criminal Court properly, and thereafter this crime of aggression was defined. You see, this Article 8 bis in paragraph 1 defines the crime of aggression for the first time. It says, what is the meaning of crime of aggression? It means planning, preparation, initiation, or execution. By whom? By those persons who are having a position by which they can effectively exercise control over or to direct the political action of a state or to direct the military action of a state. And then what will be the direction? Direction will be that you commit an act of aggression. And what this is not any kind of act which is simple, but it is by character, by gravity, and by scale, which constitutes a manifest violation of the Charter of the United Nations. Then it becomes crime of aggression. And then what are the examples of act of aggression? You see, invasion or attack by the armed force of a state of one territory or to another territory. Bombardment by the armed forces of a state against the territory of another state, or the use of any weapons by a state against the territory of another state. Likewise, you will find these are all specific instances of the crime of aggression. Now, students, you must know that this crime of aggression has been under the jurisdiction of International Criminal Court originally since 1998, but only since 2018. So after 20 years of the working of International Criminal Court, in 2018, since 2018 itself, now it has been implemented. So earlier it was just on the paper, now it has been enforced. So crime of aggression is also coming under the jurisdiction of International Criminal Court. Students, now I'll be dealing with different other types of jurisdiction. I have just now I have finished dealing with the subject matter jurisdiction, what is called in Latin ratione materiae. But now I'll be dealing with different other types of jurisdiction, like territorial jurisdiction of International Criminal Court, personal jurisdiction of International Criminal Court, and time jurisdiction of International Criminal Court. In Latin, these are called loci, ratione loci. Second is called ratione personae, and third is called ratione temporis. These are the three other types of jurisdiction that also you should know, because in your examination sometimes different types of jurisdiction are asked. Students, if you look at the Rome Statute again, you will find that Article 12, paragraph 2, subparagraph A, that deals with the exercise of jurisdiction. And it says a state which becomes a party to this statute accepts the jurisdiction of the court with respect to the crimes referred to in Article 5. So you see, this is called ratione loci. What is that? That the territory of a state which accepts the jurisdiction. So this is Article 12, paragraph 1. A state, suppose state A has accepted the jurisdiction of the court, then ICC can exercise its jurisdiction on the territory of state A, right? And then second, what is it called? It says that second situation in which ICC can have jurisdiction over a territory when a particular country's case is referred by the Security Council. So suppose if Security Council has referred a matter to the court, like I gave you the example of Libya. Now Libya has not signed the Rome Statute, but then Security Council referred the matter to the International Criminal Court. So over Libyan territory also, International Criminal Court exercised jurisdiction. So this is also given in International Criminal Court Rome Statute. It says that when the Security Council has referred a matter, then also it can be ICC can have jurisdiction. So you see, this is the jurisdiction. The court may exercise jurisdiction when a situation in which one or more such crimes have been committed is referred by the prosecutor by the Security Council. Prosecutor by the Security Council. So Security Council has referred a matter, then also what will happen that the ICC can have jurisdiction. And then Article 15, it also says that the court shall have exercise over this crime of over any kind of crimes which are committed, and then Security Council's referral. After that, ICC can have jurisdiction. Thereafter, the vessels, the ships and aircrafts which are registered in the state, in that state, and the state concerned is under the Rome Statute. The state concerned has signed and ratified the Rome Statute. And in that state, suppose, or in the vessels and aircrafts registered in that state where the crime has committed, right? So over that aircraft, even if that aircraft is in some other territory and the crimes were committed in other territory, but because aircraft was registered in the country and that country is uh, under the jurisdiction of ICC, therefore what will happen that ICC can have jurisdiction. So Article 12, again you'll see at Article 12, it says that the state on the territory of which the conduct in question occurred, or if the crime was committed on board a vessel or aircraft, the state of registration of that vessel or aircraft. So you see that this is how ratione loci, sometimes it is called ratione loci. So territorial jurisdiction of ICC is there. Now we will move on to the personal jurisdiction, which is also called ratione personae jurisdiction. Now, if you look at Article 12, paragraph 2, subparagraph B, it says that when the state of which the person accused of the crime is a national. So suppose what happens that if a country A has signed the Rome Statute, and if a national of a country A, suppose XYZ, if they have committed the crime, then what will happen that XYZ, they will also be coming under the jurisdiction of ICC because country A has signed and ratified the Rome Statute. And then if you look at Article 12, paragraph 3, it says that if the acceptance of a state which is not a party to this statute. So till now we have seen that if a state is a party, but suppose if the acceptance of a state which is not a party to this statute is required under paragraph 2, that state may, by declaration, accept the exercise of jurisdiction by the court, and thereafter the accepting state will have to cooperate with the court. It means that sometimes what happens that a non-state party, a state which is not signed, which has not signed and ratified the Rome Statute, but then another country which has signed and ratified the Rome Statute, that country's case has been referred, and suppose in that case what is the question is that another state's national is also there. Now in such case, if another state has itself lodged its acceptance of the court's jurisdiction, in such case national of that non-state party will also come under the jurisdiction of ICC. Lastly, Article 26 of the Rome Statute, which says that children should not be coming under the jurisdiction of ICC. And therefore, if you look at Article 26, it says the court shall have no jurisdiction over any person who was under the age of 18 at the time of alleged commission of the crime. So ICC does not have the power to prosecute a child below 18 years of age, even if the child belongs to a country which is a party to the Rome Statute. Now I will move on to the last jurisdiction head, which is ratione temporis, time jurisdiction. In time jurisdiction, what happens that you must be very clearly knowing that since 2002, because since 2002 Rome Statute entered into force. So any crime which has been committed and which may come under the jurisdiction of International Criminal Court, but such crimes like genocide, like crimes against humanity, like war crimes, if they have been committed before 2002, then what will happen? That those crimes would never come under the jurisdiction of ICC. Because Article 11, subparagraph 2 says that the jurisdiction of ICC will only come when Rome Statute will enter into force with respect to that state. If you look at Article 11, paragraph 2, it says very clearly that Rome Statute cannot come into force uh, with respect to the state. You see, ratione temporis. It says that the court has jurisdiction only with respect to crimes committed after the entry into force of this statute. And it further says, if a state becomes a party to this statute after its entry into force. So this is another situation. Article 11 further says, if a state which has, so there may be a situation when a country, suppose like 60 states, uh, they had signed and ratified in 2002, and thereafter it came, the Rome Statute entered into force. But suppose if a country A, which becomes a party to the Rome Statute in 2019, now in that case, what will happen? Whether a crime committed in that country A in 2002, that will also be covered under the jurisdiction of ICC? The answer is no. In such case, what will happen that because the country in question signed and ratified the Rome Statute in 2019, and then how this will be, since when the crime committed in country A will be coming under the jurisdiction of ICC, it says that it may exercise its jurisdiction with respect to that, with respect to the crimes committed after the entry into force of this statute for that state, unless that state has made a declaration under Article 12, paragraph 3. It means that for the country in question, if the Rome Statute has come into force, only then International Criminal Court will have jurisdiction over that country. So ratione temporis means that you have to know that since what time ICC will have jurisdiction. And therefore, if you look at Article 126, it further clarifies that if a state which has ratified, accepted the statute after the deposit of the 60th instrument of ratification, the statute shall enter into force on the first day of the month after the 60th day following the deposit of such a state of its instrument of ratification, acceptance, approval, or accession. So 60 days and thereafter the first day of the month. So suppose if a country A has signed and ratified the Rome Statute in the year 2020 January, then after 60 days, suppose it signed on 10th of January, and thereafter 60 days, so so that will be 10th of March. So not on 10th of March, but on 1st of April, the jurisdiction of ICC will be starting. So this is what is the effect of these all articles, Articles 11, paragraph 2, Article 24, and Article 126. Finally, Article 12, paragraph 3 is, I have already discussed with you, that an exception has been created to this general rule of temporal, means time application. It says that if a state which is not a party to the Rome Statute, it may also make an ad hoc declaration recognizing the court's jurisdiction over specific crimes. In that case, the court would obviously be having jurisdiction even prior to the entry into force of the statute. So suppose if a country which has signed and ratified the Rome Statute in 2020, but it has made a declaration, ad hoc declaration, and it has recognized the court's jurisdiction over a crime which was committed in 2019. In that case, what will happen? That ICC will have jurisdiction over the crime which was committed in that country even in 2019. So this is how, students, you must know the different types of jurisdiction. I wanted you to know all these types of jurisdiction. And now I will tell you something more about the later stage of the prosecution trial. So what happens that after the trial, suppose, is finished, and then you might be wondering that is there any kind of capital punishment? Because you might have heard, I have discussed with you that the IMT at Nuremberg, that was having capital punishment as one of the mode of punishment. The Far East Tribunal, Tokyo Tribunal, was also having this capital punishment provision. So this capital punishment provision, you will wonder that whether this is also present in the Rome Statute. The answer is the Rome Statute does not have capital punishment. It is only having life imprisonment. So life imprisonment, according to Article 77, there can be life imprisonment. So that is also possible. And then otherwise, if the person is not imprisoned for life, then a person can be imprisoned for maximum for 30 years. So you'll find that, you see that it says sentencing, Article 76, it says sentencing. And then you see that penalties, Article 77 talks about penalties. And it says that the court may impose one of the following penalties. What is the first one? Imprisonment for a specified number of years, which may not exceed a maximum of 30 years. And it also says that life imprisonment can also be awarded if it is justified by the extreme gravity of the crime and the individual circumstances of the convicted person. So life imprisonment is the exception, but the normal rule is that imprisonment which may extend up to 30 years. Apart from these kind of punishments of imprisonment, a person may also be fined, and also there is a possibility that whatever he might have earned or she might have earned by way of arrogating all the property of others, in such case what may happen? A forfeiture of proceeds, property and assets derived from that crime. So this is also possible. So Article 77 discusses about such kind of possibilities when a person is imposed a fine or life imprisonment or imprisonment not exceeding 30 years. Now I will also tell you about some, because sometimes students ask the question that suppose if there is a penalty of imprisonment, or then suppose if a country is not abiding by the judgment, in such case what will happen? Now in such case you will find that there is a role of states. I have told you that the treaty, this is the fundamental rule of a treaty, that a treaty, the party to the treaty must be abiding by the obligations contained in the treaty in good faith. So if a country has become the party to the Rome Statute and it will not be abiding by the obligations which are contained in the Rome Statute in good faith, then what will happen? The treaty, there will be violation of the treaty. So this is the role of a state, is to abide by the judgment, and if the individual states will not be willing to abide by the judgment, then there is a role of assembly of states parties. And assembly of states parties, they will also try to enforce. And if suppose after that also, if the judgment is not being enforced, in such case Security Council is again important. And therefore you might wonder that sometimes many people criticize that why Security Council has been given the function in International Criminal Court. The answer is that if all these situations fail, then there will be the role of Security Council in case of non-cooperation by the states. And then you will find that Article 87 gives the role to the Security Council, that in such case you will have to enforce the judgment of the International Criminal Court. So see, this is article, this paragraph 7, where a state party fails to comply with a request to cooperate by the court contrary to the provisions of this statute, thereby preventing the court from exercising its functions and powers under this statute, the court may make a finding to that effect and refer the matter to the Assembly of States Parties, or where the Security Council referred the matter to the court, to the Security Council. So you find that uh, Article 87 talks about the role of Security Council in case of non-cooperation by the states. Now, I have till now I have dealt with the provisions, the basic provisions of International Criminal Court, basic provisions of Rome Statute, on the basis of which International Criminal Court functions. Friends, students, now I'll be finally dealing with the prominent cases which have gone to International Criminal Court. There have been many situations and cases which are being dealt with by International Criminal Court, uh, but I'll be starting with some of the cases. I will not be taking up all the case laws, but I'll be discussing with some of the cases. Like first situation I will be discussing will be the situation from Congo, and the situation from Congo is that the Congo case is that I have cited two cases from Congo. First is the MN Chui case, and the second is Katanga case. Now you see that this person Chui, he was a colonel in the Congolese army, and he was also the military commander of a rebel group. So FNI and FRPI, these were the rebel groups. And then what he did, that there were allegations that he had committed war crimes and crimes against humanity in a village of one district of Congo. And what were the acts? The acts were sexual slavery, rape, murder, recruiting children. These were the serious offenses that he had committed. And finally, when the matter went to the court, International Criminal Court, then what happened, that he was acquitted by the trial division and also by the appeals division. So students, it is not that the International Criminal Court does not acquit anybody. It also acquits the accused, unless and until there is no fair establishment of the crimes which were allegedly committed. The court does not punish the criminals. So Chui was acquitted. Next important case from Congo, which was dealt by International Criminal Court, was Katanga case. And you will see that this Katanga was also a military commander of a rebel group, and he had led an attack on a village in a district in 2003, in which civilians were killed, 200 civilians killed. And then he had imprisoned survivors in a room filled with the dead people. And then he had also been accused of sexually enslaving women and girls. And then he had also allegedly he had killed more than 1,200 civilians in an attack in a hospital in September 2002. And you will be surprised to know that he was appointed military general in 2004 in the official armed forces of the country as part of peace process. And then finally what happened, that he was arrested when he was accused of killing 9 United Nations peacekeepers in one district of Congo. And then he was arrested, and then he was brought before International Criminal Court, and he was accused of committing war crimes and crimes against humanity. And finally the case was heard, and finally he was punished for 12 years of imprisonment. So these are two important examples from Congo. Now I will move on to another example, which is referred by the state which is called Central African Republic. So this is one of the states of Africa. From that country, one famous case is a Bemba case, prosecutor versus Bemba. And you see, this is Bemba. He was arrested in 2008 near Brussels. And this is the judgment of the International Criminal Court Appeals Chamber in 2018. What you will find, that he was a military commander of a rebel group which is called Movement for the Liberation of Congo, MLC. and thereafter what happened that he became popular, and he was later, he had founded the political party, and thereafter what happened that he was a very influential person in Central African Republic. Allegedly, he had committed crimes against humanity of murder and rape. He had also committed war crime of murder, rape, and pillaging by these rebel groups. He had also recruited children, and therefore, what happened that he was held guilty by the trial division, and then he was punished for 18 years. But appeals chamber acquitted him on the ground that Bemba's ability to investigate and punish crimes that was limited. So you see that again in Bemba case, it was not that Bemba was punished by the International Criminal Court. Bemba was acquitted because the court looked at every detailed evidences which were produced by the prosecutor. Finally, I will also take you to one example from Ivory Coast. This is again a famous case decided in 2019 by the trial chamber. This is Laurent Gbagbo, prosecutor versus Laurent Gbagbo and Charles Gaudet. So in that case, what happened that Mr. Laurent Gbagbo was the president of Ivory Coast. And you see that before becoming the president, he was a political leader. And what happened that when he had lost election, then after election, what happened that there was a violence, a civil war kind of conflicts. And he had led a march in a particular city, and then thereafter he was also accused of killing some of the women during a women's demonstration, and he was also accused of shelling a densely populated civilian area in one district, and then in another district also. So allegedly he had committed crimes against humanity. So what happened that this Laurent Gbagbo, what happened that he was acquitted by the trial chamber. So appeal is still pending. Maybe that this appeal will be filed before the appeals chamber. But then I am giving you the example that from Ivory Coast also, this person, very influential person, president of Ivory Coast, he was arrested and he was tried before International Criminal Court. And then after that, what happened that when the trial was finished, he was acquitted. So the main thing what I am telling you that International Criminal Court is not such kind of court which is always punishing the person who are arrested and brought before it. This is a different kind of international institution which runs on a statute which is known by the international community, which is not instantly made. It is already there. People can see, people can examine, countries can examine it, and after that it can sign and ratify and see that, okay, how this International Criminal Court is functioning. So these are some of the things that I wanted to share with you. And if you have any questions, then you may send it on my Google Classroom page. Thank you very much. Take care and be safe.